Okay, this video is about the probable cause hearing that just concluded 40 minutes ago for Patrick Gordon's case. If you are unfamiliar with this case, please view this video. Receipts don't lie. Mass State Police caught falsifying probable cause. As soon as I'm able to put a link in the upper right corner of this video, I will add it to the timeline on YouTube Editor. All right, so here is the hearing.
He's in custody, Judge.
Okay.
I can waive his appearance for purposes of getting another date unless he's on. No, he's not on.
Okay.
That's fine.
Here is the first PC date. We were looking for further time to present this matter to the grand jury. This matter handled by the Attorney General's office. I've talked with counsel about further dates. We're looking for March 4th, if that's agreeable with the court.
That's a good date.
It is, Judge.
Okay, March 4th by agreement for the probable cause.
Waive his 30 days, Judge.
Okay,
Thank you.
all right.
I had to say it.
So he's in there.
And then there was a case downstairs that got bounced back and forth. Yeah, okay.
This is really a fucked up case. So anyway, in Massachusetts, I want to address what a probable cause hearing is in Mass, okay? So there's a few things, right? So what I did is I found the only video on YouTube that I could find talking about probable cause hearings in Mass, and I used AI to summarize it, and then I imported that summary into ChatGPT, and I also asked ChatGPT to pull from other sources on Massachusetts case law and to compile that into a viewer-friendly explanation. All right, so here is an explanation. What a probable cause hearing is supposed to do in Massachusetts. In Massachusetts District Court, a probable cause, or a PC hearing, is meant to answer one narrow question. Is there enough evidence to move the case forward to Superior Court? It is not a trial. It is not about guilt. It is a screening mechanism. At a real PC hearing, the prosecution must present actual evidence. Witnesses may be called. The defense can cross-examine, and a judge decides whether the case is bound over to Superior Court. If probable cause is not found, the case ends at that stage. Why prosecutors avoid PC hearings? In practice, prosecutors strongly prefer not to hold these hearings. Reasons: they must reveal evidence early. Witnesses testify under oath and can be cross-examined. Witnesses in the case become visible and recorded. Inconsistent police testimony becomes discoverable impeachment material. This is why PC hearings are rarely completed, even when scheduled. The alternative prosecutors prefer is a grand jury indictment. Instead of a PC hearing, prosecutors usually seek a grand jury indictment. Key differences: proceedings are secret. Only the prosecution is present. No judge evaluates credibility. No defense attorney. No cross-examination. The prosecutor decides what evidence a grand jury sees. The probable cause standard is the same, but the process is entirely one-sided. From a prosecution standpoint, this route is safer and easier. What the fuck? All right, now let me see this. Oh. Also, I want to just throw it out there that I'm a carpenter. I am not an attorney. This was a subscriber on my channel, and I looked into this case because it was applicable to me, and when I investigated it, I became extremely suspicious, and then found some real fucked up shit. And this kid should be out. He's not a kid, he's older than me, but he should be out of jail. This is absolute insanity. What happened in this case, the continuance tactic? When a judge schedules a PC hearing and then continues it 30 days out, this typically serves one purpose: to give the prosecution time to secure a grand jury indictment instead. This pattern is common in Massachusetts district courts. Defense requests a PC hearing. The prosecutor is not ready or does not want to proceed. The judge grants a continuance. The prosecutor uses the time to go get a grand jury, or to go to a grand jury. District court case is later dismissed, and the defendant reappears in Superior Court on an indictment. The PC hearing never happens. Why judges allow this? District court judges have wide discretion over continuances, rarely force prosecutors to present evidence early, often defer to the prosecutor's claim that they need more time, in quotes. Even when the defense objects, the continuances are commonly granted. This effectively neutralizes the PC hearing as a meaningful safeguard. What this means for defendants, for someone accused, the case remains in limbo. Restrictions on liberty continue. Legal costs increase. Public stigma remains. And no evidence is tested in open court. The delay benefits only one side. The bottom line for viewers: a probable cause hearing is supposed to be a check on weak or unsupported arrests. In Massachusetts, they are rarely allowed to occur. Continuances are routinely used to avoid them, and grand juries replace open court scrutiny. The process favors delay over disclosure. When a judge reschedules a PC hearing instead of holding it, it is usually not about fairness or preparation. It's about preserving prosecutorial control of the case. Okay. That blows. Now, what I did is I said, okay, ChatGPT, I have a sneaking suspicion his public defender needs to be more aggressive. Anyway, and then I also, I took the description from my last video and I uploaded it into the prompt. And then I also asked, in terms of how does this apply to this case, right? How my investigation fits directly into the defense strategy. All right, let's see. How police falsehoods on a warrant control the entire case. A criminal case built on a search warrant stands or falls on the truthfulness of the affidavit used to obtain it. If the affidavit contains materially false statements or material omissions of exculpatory facts, and those falsehoods were necessary to establish probable cause, then everything derived from that warrant is tainted. This is not procedural trivia, it is structural. The legal mechanism, Frank v. Delaware. Your findings map cleanly into a Frank's violation, which has three elements. 1, a false statement or omission in a warrant affidavit. 2, knowing, intentional, or reckless conduct by police. 3, materiality. The warrant would not exist without the falsehood. Your evidence addresses all three. The receipts contradict sworn claims. The store owner confirmation removes ambiguity. The Attorney General's photograph corroborates the receipts. And the alleged prohibited items are central to probable cause. We had a cop explicitly lie and knowingly lie that he saw this guy purchase high-capacity magazines in New Hampshire, then transport them across state lines. Okay, please check out this video if you haven't seen it yet. If the alleged purchase never happened, the warrant collapses. Why this is more powerful than arguing facts of the crime. Your analysis avoids weak defenses like intent, knowledge, chemistry debates, and post hoc explanations. Instead, it attacks the legality of the government's conduct. Courts are far more willing to dismiss cases for constitutional violations than to acquit defendants on disputed intent. This is why prosecutors fear Frank's hearings. How this ties directly into the probable cause hearing delay. This explains the continuance tactic. A district court probable cause hearing would force testimony under oath, lock officers into statements, expose contradictions with receipts and photos, create impeachment material before superior court. That is exactly what the prosecution wants to avoid. Delaying the PC hearing while seeking a grand jury indictment keeps the false affidavit insulated, prevents cross-examination, avoids judicial scrutiny of the warrant, buys time to reframe the narrative. Your investigation makes a PC hearing dangerous for the state. Suppression equals case collapse. If a Frank's hearing is granted and the false statements are excised, probable cause disappears, the warrant is void, evidence seized is suppressed, arrest becomes unlawful, charges become unsustainable. This is not a mitigation strategy, it is an extinction-level event for the prosecution. And I said, does the public defender need to be more aggressive? From a strategic standpoint, a motion to suppress based on Franks is mandatory, not optional. Delay benefits the prosecution, not the defense. Silence allows the state to control the timeline. Failure to litigate affidavit falsity early forfeits leverage. An aggressive defense posture here means forcing affidavit scrutiny immediately, opposing continuances on the record, preserving issues for appellate review, creating a documented constitutional conflict. A passive defense allows the case to migrate quietly to superior court, where suppression becomes procedurally harder and politically costlier. Ooh. Okay. Why your video matters. Your work does something defense counsel alone often cannot. It preserves evidence publicly. It fixes contradictions in time. It prevents quiet narrative rewrites. It raises the institutional cost of misconduct. This is not advocacy, it is documentation. And in constitutional litigation, documentation wins. Bottom line, your investigation is not ancillary content. It is the core legal pressure point in the case. If the affidavit is false, the arrest is unlawful. If the arrest is unlawful, the prosecution has no foundation. Everything else is noise. This is why the system delays. And immediately, you can see down here, I'm like, create a GoFundMe description for this. So, needless to say, dude, I mean, this is how it is, right? I've had public defenders in the past who were really fucking great aggressive attorneys who were just filling their hours for their pro bono, the required pro bono for the Bar Association, for their firm or whatever. Sometimes you luck out and get a really good one. This guy, I don't know. This guy just signed on the 16th, so he has no fucking idea what's going on. I did email him Friday night with all the information I picked up from my investigation. He did not respond over the weekend. And then yesterday, which was Monday, Martin Luther King Day, court was closed, but I fucking texted him again at 8:30 in the morning. And what did I send him? Let me just review this, just because I'm documenting this stuff. I just want to document all of this stuff. All right, so I forwarded this PDF right here, which basically is the court-friendly version of my video, right? Of that last video, which you should see. And then I sent it to him via text message. And it was because it was too large to send via email. And today so that was Friday at 8:27 p.m. and today at 8:25 a.m. He says, Tim, I am an independent investigator that works for an investigative agency. I am not a direct employee of Salem District Courts or the Public Defender's Office. The Committee for Public Counseling Services is one of my agency's clients. The public defender gives us very limited budget to conduct preliminary investigations prior to court proceedings. I was not tasked with conducting investigations into the state police or any evidentiary findings. I have forwarded everything you have sent to me to the public defender as of the end of last week. Okay. All right. I don't know. All right. The case was closed on my end with my agency. I am no longer allowed to do any work on this case. Please forward any further correspondence to the public defender's office or Salem District Court. There is nothing further I can do from this point. And I said, okay, thank you. I went to check the case files, which I'm going to go do again today. And I noticed that a new attorney signed on from Lawrence. So now I send this new attorney, I said, Patrick Gordon's defense team. This was yesterday at 8:55 a.m. I'm following up because I've not received any acknowledgement from either counsel or the investigator, despite multiple attempts to share material that is directly relevant to the defense. I have produced a video laying out documentary evidence showing material false statements and omissions in the search warrant affidavit used against Patrick Gordon. The central claim in the affidavit that Trooper Babaker observed Mr. Gordon purchasing gun magazines at State Line Guns is contradicted by objective records. Store receipts provided by the owner and contemporaneous photographs showing the purchase was limited to small pistol primers only. This is not an opinion issue. It is a verifiable, factual contradiction that goes directly to probable cause and supports a Frank's challenge. If raised properly, it creates a clear path to suppression and potential dismissal. The video was posted 17 hours ago and already has thousands of views, with uniform public recognition that the warrant narrative does not match the evidence. I am not asking you to rely on public opinion. I am pointing out that the documentation exists, is preserved, and is already public. I'm asking for a simple acknowledgement of receipt and confirmation that this information will be reviewed. Ignoring it exposes the defense to serious questions later if this evidence is not raised. Please acknowledge receipt. Me. All right, then I sent them a link to the video. Receipts don't lie. Mass State Police caught falsifying. And then I also sent them an AI summary of that video, right? And so I did get acknowledgement from both the investigator, who is now off the case because he used up his $500 budget, just fucking insane, and then his new attorney, Philip Doherty. Thanks for the information. ChatGPT can be a useful tool. We use it. All right, so he was friendly, but he just came on. But at this point, dude, I'm highly skeptical of his defense team. You know, anytime you have a defense attorney shaking hands with the prosecutor, I understand the amicability, but like when they're potentially prioritizing this friendly relationship with prosecution, I mean, this is something I've heard a number of people say, particularly in jail, is that, their defense attorneys go out to lunch with the prosecution. It's like, dude, this shit should be being fought aggressively. Anyway, so, I'm at the point now where I'm like, motherfucker, I'm starting to GoFundMe for this dude. We need to get him an aggressive attorney. I'm reaching out to the public or any of my viewers. If you have any sort of connection with a criminal defense attorney in Massachusetts who is, aggressive enough to take this and to I think that there's a very high probability of fucking, I'm handing them a layup. This is a layup, dude. Like, and it looks, on first appearance, this case looks unbeatable. He's got tattoos all over his head, like, but this is a situation that is not what it seems. And this would be a massively public, advertising for any sort of criminal defense attorney. I would be all over this case, dude, with this kind of layup. You know what I mean? Like, I've already done all the fucking legwork. We have like a clear, Frank's violation here. And anyway, link in the description for Patrick's defense GoFundMe. Please donate. I have deleted my channel donation page off of my YouTube bio, and in lieu of donations to my channel, I want that money to go to Patrick Gordon's defense. Also, check out inventionincarnate.com for some cool fuses and igniter kits. And on February 11th through the 16th, I will be at the Western Pyrotechnic Association Winter Blast event. I will be teaching seminars for 3 days on smoke compositions, the INV-83, and rearming fuses. It's going to be fucking awesome. So anyway, okay, goodbye, I love you. I will keep you updated. I swear to God.